Hello, this is Attorney Anthony Wright in Las Vegas, Nevada. This video is part of a video series that I'm doing to help prepare clients for trial. These videos are not going to be published to the general public, but will be provided to clients and their witnesses. This particular video will be for witnesses. I find myself repeating the same lecture over and over again to parties and to witnesses. Sometimes I spend hours talking to up to 10 witnesses in a case about what will be expected of them at trial and how to prepare. So this video is intended to give general information to help prepare the witnesses and the clients, but that doesn't mean that I won't still discuss the case with the witnesses or client to get more specific details and so forth. It'll just save a lot of time. So today I'm going to talk about what to expect if you are called as a witness. How will you even know if you're called as a witness? Well, either you'll get a subpoena, which is a court document saying that you have to appear at a certain day at time at a certain place, usually the court, or somebody, a party or a lawyer, will contact you and say, hey, we're planning to call you as a witness. Please let's discuss what you might have to say, what you might testify to. If you are subpoenaed, you can use that subpoena perhaps to get out of work. You show it to your employer and say, I have to go to court. If you're a friendly witness and you're taking a day off, you may not need to be subpoenaed. You'll just show up. Subpoenas cost money and time. So if you're a friendly witness, you might want to help your friend out without making them go through the subpoena process, unless, of course, you need it for a job to get out of work for the day. Now, if you are a friendly witness, that means that you're either a family member or a friend or somebody who's just generally going to have something good to say for my client's case. An adverse witness would be somebody that's probably more biased in favor of the other party. But you could be called as an adverse witness for my client. Say you're the parent of the other party, but I'm calling you, even though you have an obvious bias, I'm calling you because I want you to testify about something. So if you're likely to agree with the person that's calling you, you would be a friendly witness. If you're likely to disagree with the person calling you, you would be an adverse witness. Question I get is, will I actually be called to testify on the day of trial? In other words, should I even show up? The question is, it's not really clear until the day of trial whether your testimony will be needed. I like to have all my witnesses there. I like everybody to see the show of support to my client. Whether I call the witness or not will depend on how the trial is going, what has already been testified to, what's been admitted into evidence, what still needs to be admitted to evidence. Courts don't like duplicative testimony. That's testimony that repeats itself. So if one witness already testified to something, we may not want to call another witness to say the exact same thing, unless it's important to corroborate because the facts might be in dispute. Maybe a witness has been called a liar, so we bring in another witness to corroborate the prior witness's story. Timing is an issue. If we only have 1.5 hours to present our case, it's very difficult to get a lot of witnesses in such a short amount of time. So the important thing is that you're there. You may have to dedicate 3 hours, 8 hours, 12 hours, however long the trial is. Usually if it's a multi-day trial, we'll have some idea whether you're going to be called on one day instead of another. So you may not have to be there on every day of the trial. So what happens when you're called? You're usually going to be outside the courtroom and the marshal will come out and say, hey, Mr. So-and-so or Mrs. So-and-so, please come in. When you come into the courtroom, you'll be asked to identify yourself. You'll have to walk up to the witness stand, which is close to the judge, and you'll be asked to identify yourself and spell your name for the record. And then you'll be sworn to tell the truth. And then an attorney or a party will start asking you questions. And what will the questions be like? Well, if you're a friendly witness, then your friend or family member's attorney will begin asking you what are called open-ended questions. This is called direct examination. Open-ended questions are questions that answer the 5 W's: who, what, when, where, or why. Who, what, when, where, or why, the 5 W's. They are not questions that will elicit a yes or no response. Questions that elicit a yes or no response are called leading questions, and those are impermissible on direct examination of a friendly witness. If there's an objection to a question, the other side objects. Objection, Your Honor. You're not to continue answering the question until the judge rules on that objection. If the judge sustains the objection, that means you're not to answer the question. It was an incorrect question. You should not answer it. If the judge overrules the objection, then you may continue to respond to that question. So in order to prepare for testimony at trial, it's a very good idea, in fact it's critical, to think of a few very clear incidences, observations, personal eyewitness events or ear witness events that you can attest to. You're going to want to, again, answer who, what, when, where, or why. So prior to trial, you might want to think of those 3 to 5 incidences and maybe prioritize them, the ones that are the most important to the case. For instance, witnessing the interaction of a child with a parent if it's a child custody hearing. Witnessing the dynamics between the parents. When did you see it? What did you see? What happened? You know, how did the people act or react? What did they say, etc. Now, if you cannot remember something, it's okay to say, I'm having a little trouble remembering. Give me a moment. I'm trying to recall the details. Obviously, though, if you've prepared in advance of trial, you should be able to remember these things more quickly. But if you're really struggling with something, it may be possible for the attorney to help you a little bit to recall. Like, for instance, you're trying to remember an incident. I could maybe ask you, do you recall if it was this year or last year? I can lead you just a tiny little bit just to get your orientation fixed. Can't lead you too much or it'll be objectionable. Or if you need to have your memory refreshed, I may have a document that you can look at, a picture or something to help you remember what happened. Do not lie. Never lie under oath. If you think that your testimony does not sound credible, you might want to think about how you can bolster your credibility. You may have documentary evidence provided to an attorney that can help establish that what you're saying is true. You might even say to the judge, this sounds kind of weird, but this is what happened. You can acknowledge that it's a weird thing you're about to say. If you have lied in the past when you were not under oath, but you have to tell the truth now and you know that your prior lie is going to be exposed, you might want to prepare for that and explain that you had lied in the past and why you did it and why you're telling the truth now. For instance, a person may have lied in a text message, so there's documentary evidence of the lie, and they may have lied to keep the peace or to protect someone. I lied because I did not want this person to go to jail. I lied because I did not want him to beat her up. I lied because I wanted to make sure the children were safe. But now that I know they're safe and I'm under oath, I want to tell the truth. Okay? That's important. And sometimes you want to put that up front because you know the opposing party is going to try to expose your lies. and impeach you on the witness stand. So sometimes you may need to just explain up front so the judge knows that you're being as honest as you possibly can be under the circumstances. Now, if you're not a friendly witness, meaning you have a bias against my client, then it'll be obvious to the court what your particular bias is, because you're going to identify the the parties, and your relation to them. If you're the best friend of the other side and I'm calling you to testify, well, there's an obvious bias, but you still have an obligation to tell the truth. You just may not want to tell the whole truth and nothing but the truth. And if you're acting strange about answering questions, I might ask the judge to declare you a hostile witness based on your bias, in which case I can then, instead of asking open-ended who, what, when, where, why questions, I can ask you leading questions, yes or no, to get you to answer clearly yes or no to certain things. And if you're hostile and you're trying to lie, I will catch you in your lies. Either I'll catch you right then and there, or I'll catch you with an impeachment witness that shows that you're not credible. And I might even call you to testify about what you said in the past, and your prior lies, and try to get you to clarify why you lied to people in the past, or why you're telling the truth. Or maybe you are biased for the other side, but you really do understand that you have to tell the truth, and you want to not look bad to your friend, but at the same time need the truth to get out. So being treated as a hostile witness allows you to save some face with your best friend while still telling the truth. Instead, I had no choice. I had to tell the truth. Okay? You'll know that a question is leading usually if there are other words in a question like, isn't it true that, or you did this, didn't you? Or it's true that, or the fact is that this happened, right? These are all leading because they elicit a yes or no response. All right, when the other lawyer has an opportunity to cross-examine you, this is called cross-examination, they can lead you. In fact, they should lead you. They shouldn't allow you to explain yourself. They are limited, though, to asking you questions about what you just testified to under direct examination. If they go too far afield, there will be objections hurled, and the court will say to the opposing counsel, stop that line of questioning. That's beyond the scope of direct examination. The leading questions will be designed, usually, to try to make you look like you're not credible to the court and that your testimony was useless. So it's very important. The who, what, when, where, or why questions are way more important than character questions. Oh, you know, my daughter is a very good mother. I just know she's a very good mother because I'm a good mother and I know what a good mother is. Yeah, who cares? I mean, you can say that briefly, but you better have something more substantive to offer to the court. Specific examples, and if they can be corroborated by documentary evidence and pictures and videos, so much the better, okay? Otherwise, you're just a biased witness and kind of pointless to the court, because the court's going to assume that, of course, you're going to say nice things about your own child. But not always. Some parents will have negative things to say about their own children, particularly children that have disappointed them many times, might be on drugs or whatever, and they're really interested in protecting the grandchildren at that point. After the other lawyer will have an opportunity to do what's called redirect. This is where, if I'm the one who called you as a witness, would have the opportunity to ask you follow-up questions to try to explain some of your answers. If under direct examination it looked like you lied or just something doesn't seem right, I then have a follow-up opportunity to help you clarify to the court why your testimony is still credible. Okay? I hope that is helpful. Again, I will be meeting with either on the phone or in person with witnesses in advance of trial, sometimes for 5 or 10 minutes, sometimes longer. But this video, you can play this over and over again and really prepare and really think about what you might say at trial. I don't coach people beyond just this general type of information. I don't coach them. I don't tell them what to lie about or tell the truth about or any of that. I give them this kind of information. Okay? So if you have any questions, though, about any of this content, you can call my office and ask to talk to me directly about it. I highly advise reviewing this over and over again to prepare for trial. You're not going to be allowed to read from your notes at trial. You can have notes handy and ask if you can refer to your notes to refresh your memory, but you don't want to be reading from your notes. When you got to recall from your memory, so the judge knows that you're remembering it. This wasn't written for you by someone else and that you're just reading it, okay? So anyway, I hope that's helpful. I think it'll save a lot of time and money for clients. And good luck.